And welcome. Thank you for joining me today on this live stream session. This is your employment law live stream session. This is where you get to be informed and educated about this very important topic. So this is when you can ask me a question about employment law rights. And so I guess I got to tell you who I am. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. I'm one of the founding partners of the firm. Our firm, you can find us across Ontario, BC, and Alberta. And once a week, sometimes twice a week, I log in right here on social media and open it up for your questions. This is a live Q&A type of a situation. You get to ask me a question about your workplace rights. If you want to know about your severance package, if you want to know about your employer's behavior, about the ultimatum that the company is giving you, about being off on a medical leave, about being off on a parental leave, you name it, if it touches on the workplace, on employment law, on those workplace rights, to get some answers, to get some help, and to get some knowledge. The reason I'm able to do this is because we have a lot of good, fantastic, in fact, workplace rights. You all have workplace rights. Unfortunately, not everyone knows what those rights are. There's a lot of misconceptions out there. A lot of people believe that they have less rights than they actually do. Well, you don't have to worry about that. On this session, like we do every time, you can get some questions answers. You can get some help. I'm going to start answering some questions. So let's not waste this opportunity. If you're dealing with a problem in the workplace, let's share that burden. You don't have to deal with it alone. I'll help you right now. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you've landed on my live stream session. Before I get started answering questions, let me give you some contact information. If you want to connect with me and my team off social media, if you want to have a private chat or private email exchange, very, very easy to do. All you have to do is go to employmentlawyer.ca. See that address on the screen, employmentlawyer.ca, and the phone number is there. The email address is there. You can fill out a form if you prefer. It's all right there for you, your one-stop shop for anything and everything employment law, and of course to get a hold of me. So again, employmentlawyer.ca. But right now, I'm with you here live. I'm here to talk about employment law, workplace rights, workplace questions. So I think we got to get started with answering some of those questions. Again, Lior Samfiru, that's me. Let's get some questions answered. First question, and thank you for that. Jared has a question. May I ask how often with a termination for cause and no severance, how successful are employers in this regard? So Jared, it is extremely difficult for an employer to be able to legally terminate employment for cause and not pay severance. It is very difficult. The company would have to show that whatever the employee did was so bad, it was so outrageous that it's not possible to continue employing them. That is a very, very high standard. It is not enough for the employer to say, yeah, the person didn't do a good job, or the person made a mistake, or there was a problem with the employee's conduct. That's not enough. That's not cause. That does not allow the employee to not get severance. That employer still has to pay full severance. So back to your question, the vast majority of times when an employer terminates for cause, it's not cause. That employee is owed severance. And yeah, we're able to resolve it quickly and on good terms. It is quite rare for the employer to properly terminate for cause. So Jared, if you've been let go for cause, unless you committed fraud or you hit someone or you stole, unless you did that, it's probably not cause, and you probably are owed your full severance. So you want to connect with me off air, Jared, and I'll help you get that severance. Of course, to connect with me, it's very easy. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. Connect with me, and let's get to work helping you. Fantastic first question. We got going on that one. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm here live. This is your live question and answer session about employment law, workplace rights. I'm going to continue answering the questions that have come in. I see a bunch have come in. Bring yours. You have time. Don't waste this opportunity. All right, let's see. Global ABA has our next question. My job is forcing people out. I work at a restaurant under a corporate chain. They have been writing people up for not bringing in sick notes. They have also been firing people because they no longer fit the atmosphere and are cutting our hours for not getting Google reviews. Hold on. Sorry about that. What can I do is the question. So here's the answer. If your employer wants to let you go in these situations, they're allowed to, but they have to pay severance. Remember the general rule: your employer can let you go for most reasons as long as severance is paid. What they cannot do is they cannot reduce your hours, they cannot stop giving you hours. That's a constructive dismissal. If your employer does that, that may allow you to consider your employment as being terminated. Okay. So now, if they're writing you up, it means nothing. Don't worry about that. Ultimately, if they want to let you go, they're going to have to pay severance. So they don't have to write you up for that. What I'm concerned is if they start reducing your hours, if you accept that reduction, you continue working, you've given them the right to do it again. Remember, your employer cannot just reduce your hours. But if you accept it, now you've created this new term of employment that gives them the right to do it again. You don't want that. All right. But if you lose your job in that situation, let's talk. Your employer may try to avoid paying you severance. Not legal, not possible. Let's make sure you get it. And of course, that severance could be as much as 24 months pay. Fantastic. Thank you for that question, Global ABA. I'm going to continue answering questions. If you've just landed here on my live stream session, welcome. Thank you for being here. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I see a bunch of questions have come in. I'm going to answer them. Your question will get answered. Okay. So let's continue answering questions. Ron has our next question. I've been forced to resign as the company have locked me out of the system and I cannot do my job. I'm an insurance broker and have been with this firm for almost 9 years. Well, obviously something tells me, Ron, that there's more to the story, right? Because they're not going to presumably wake up one day and just lock you out of the system. But here's the thing. If the company is locking you out of the system, that is a termination. That's not a resignation. If they're actually stopping, physically preventing you from doing your job, that's a termination, even if they don't call that, even if they don't say those words, which means you're owed severance. It's not a resignation. A resignation will be a situation where you come into the office one day and you tell your employer, hey, employer, you know what? I've decided I just don't want to work here anymore. I'm going to find another job, so I'm leaving. That's a resignation. But if the company says you can't work anymore here, we're going to lock you out, you don't have access to do your job, that's a termination at that point, Ron, and you are owed severance. So it's never a good idea to resign unless it's voluntary. But certainly in your case, if they locked you out, that's a termination. Obviously, it sounds to me like there may be a bit more to the story. So here's the best advice. Let's connect with me by phone or email. You can do that through employmentlawyer.ca. We'll have a chat and I'll help you get that severance that you're owed. And by the way, if you're an insurance broker, even if they call you an independent contractor, nonsense. You're an employee, you're owed severance. All right. Next question is from Shadow Fire XX. I found out today I am being terminated without cause due to restructuring. My last day is May 23rd. I'm wondering, have I gotten enough severance due to it being so short notice? I was there for 3 years. So you didn't tell me what severance you've been offered, so I don't know. But let me tell you what severance you'd be owed. You also didn't tell me a kind of job you had or your age. But after 3 years, it's probably going to be somewhere between 4 and 9 months of severance, depending on your age and the type of job that you had. So that's what severance for you would be like. Of course, you haven't told me what it is, so I can't tell you if it's good or not. But unless you've been offered that, somewhere between 4 to 9 months, you've been wrongfully dismissed. You got to connect with me. Of course, a wrongful dismissal, for those wondering, is simply a situation where you've been let go without proper severance. Again, no severance or improper severance, that's a wrongful dismissal. So Shadowfire XX, that's the answer. You can connect with me through employmentlawyer.ca, and I'll help you make sure we get that. employmentlawyer.ca, and I'm Lior Samfiru, the Employment Lawyer, live. You still have time. Okay, I'm back live. Sorry about that. Let's continue with questions live here. Lino has our next question. I use my personal monthly transit pass to commute to work, but I also had to travel to various work sites within the city. My employer refused to reimburse any transportation costs, arguing that I already used the pass for personal commuting. Is that legal? Should they have reimbursed part of the cost and the travel was work related? So if you did not incur additional costs because of work, that there's nothing to reimburse. If the same pass or didn't cost you anything, they're not legally obligated to pay part of the pass. You can tell them moving forward you're not going to get a pass, so they're going to have to reimburse you, and that's okay. But if you have not actually incurred any costs, you're not out of pocket because of it, because you would have spent the money anyway, then there's nothing to reimburse, Lino. Hopefully that makes sense. Any follow-up questions, ask them right now. Oh my gosh, lots of questions today. Let's continue answering. I'm not going to dilly-dally. Let's make sure we get you some questions right here. I'm Lior Samfiru, the employment lawyer. Paul has our next question. I was let go after 18 years without cause, but it was because I didn't want to sign a wage agreement. Is this not a constructive dismissal? Well, no, it's not a constructive dismissal. It's a dismissal, right? A constructive dismissal happens when the company's not letting you go, but you're choosing to consider that a termination. In this case, you were actually let go. So it's a regular dismissal. So it's really a question of severance. If you were there for 18 years and you were let go, now I don't know your age and I don't know what job you were doing, but you're probably going to be looking at somewhere between 16 to 24 months of severance. So that's what's at stake here. Not a constructive dismissal, just a regular dismissal. If you're let go, it's never a constructive dismissal. If you're let go, it's just a dismissal. So, Paul, we need to make sure you're getting the severance that you're owed. After 18 years, you have substantial entitlements. It could be as much as 24 months' pay. So, Paul, you want to connect with me as soon as possible, okay? Or you can ask a follow-up question right now. Best advice, though, let's connect off air. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. And I'll help you get that severance. Don't sign anything, okay? Be smart. Don't sign anything now without speaking to me first. All right. Let's see. Where are we next? I answered that. Okay. Ron says they're not offering me any severance as they're saying I'm an independent contractor. I addressed that. You're not an independent contractor. You are an employee. If you had a job, you're an employee. An independent contractor is someone that has several clients. They do work for various people. They manage a business. If you're managing a business, let's say a plumber. So, you have a problem at the house. You call a plumber to fix that problem. That plumber fixes your problem and then goes on to the next customer and then the next one and the next one. And they manage that plumbing business. That plumber is not your employee, even though they were at your house. They're an independent contractor. But if the plumber only worked for you and came to your place and worked at your place 9 to 5, Monday to Friday, every day indefinitely, well, they will become your employee. So are you like the plumber or not? But Ron, you're not an independent contractor. You're an employee. And what the company says that you are or what piece of paper you may have signed is not relevant. Okay? So Ron, you're owed severance. You want to connect with me, employmentlawyer.ca. All right, let's see. Is down here. Lino has a follow-up question. I work in a company where my colleague, who is of Indian origin and holds only a master's degree, is treated very favorably by our boss, who is also Indian. Meanwhile, I have a PhD and feel targeted. So what you're looking at or what you're describing could be considered discrimination, a human rights violation. If you're mistreated based on your race or ethnicity, that's illegal. If you can establish that, that could be a human rights violation, not legal. You should never be mistreated because of that. If you think that's what's going on, let's talk about it, see if it makes sense to pursue it. You can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. Ermeli, my IME says I go to work somewhere. Is this legal? Not sure what that means. Next question from Ken O'Keefe 1. I am 69 years old, working for my employer for over 15 years, no union. In 2022, took 5 weeks medical leave, and I was asked to complete a daily tracking record every minute for what I did and how long. Well, here's the thing. If this happened 3 years ago, there's not going to be much that you could do right now. I'm not sure I understand. I think you're saying that for the 5 weeks you had to complete daily tracking record. No, they're not required. That would be illegal. It's over the top. But if this happened 3 years ago and it's done already, there's not much that you can do right now. Okay? But certainly at the time I could have said that could be a human rights violation. That could be a constructive dismissal. But if it's been 3 years, there's probably not much that can be done now. By the way, if you've just joined us here, you still have time to get questions answered. I'm Lior Samfiru, the employment lawyer. I have questions here to answer. I'm going to do that right now, but you can ask yours as well. Listening to me is fantastic. Asking a question, even better. All right, let's see. Next question from Rashawn. I filed a discrimination charge with the state in Ohio. Can't help you. This is in Canada only. New name has our next question. I threatened to report my employer for intentional and malicious misclassification, and they put me on an unpaid suspension as a response. What can I expect in reprisal damages if I claim a constructive dismissal? Well, I don't know anything about your situation. I don't know how long you've worked, what your compensation was, what job you were doing, so I can't say, but you could have significant entitlements. In cases like that, because we would have a lot of leverage, not difficult to resolve. All right. So new name, you got to connect with me as soon as possible at employmentlawyer.ca. Again, employmentlawyer.ca. All right. Shadowy Fire XX has follow-up. Age 24 male. Yearly salary is $42,000. Terminated without cause today. Last day is May the 23rd. Lump sum is 11.7K for 2.8 months. Is this fair? You're probably owed about 4 months' pay. So this is about a month and a bit shy of what you're owed. Okay, so no, it's not fair. You are owed more than that. And happy to connect with me with you. You can connect with me and my team through employmentlawyer.ca. All right, fantastic question so far. Okay, I'm almost caught up here. Yeah, I think I've answered that. So I am caught up on that. So fantastic questions, by the way. We've talked already a lot about, let's see. Oh, I think I'm back. My connection was lost again. Sorry about that, everyone. But I'm back here, and we've been talking a lot about severance. Before I continue, I want to tell you how you can find out yourself how much severance you are owed. It's so easy to do. All you have to do is go to employmentlawyer.ca. Sorry, you have to go to pocketemploymentlawyer.ca. You see that address on the screen? Pocketemploymentlawyer.ca, and use our severance calculator. It's so easy to use. It takes seconds. It's free. It's anonymous. And you can find out if what you've been offered, the severance you've been offered, is it fair? Is it not fair? How much more are you owed? It's a tool that over 2 million people have used for good reason. You need to know that information. If you lost your job, of course you need to know. But maybe you're worried about losing your job and you want to know how much severance you would be owed. Maybe you're not even worried, but you just want to know. You're curious. Do I get 2 weeks severance, 2 years severance? What do I get? check out pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. All the information is right there. And just click on the severance calculator. But right now, I'm still live with you. You still have time to get some questions answered. So I say we answer some more questions. Next question is from Erant. Someone is harassing me virtually, but anonymously at work. I've reached out to HR and I've made a police report. I haven't engaged. I've blocked them almost everywhere, but they keep finding new platform to reach me on. I don't feel safe or comfortable. It's been weeks and nothing has changed. Is there anything I can do? I'm not a tech expert. I can't tell you what you can do. I really don't know. You may want to talk to someone that has some knowledge about tech issues, and perhaps they can give you some advice as to the question. Not really an employment law issue, so I can't really answer that. Darlene has our next question. I was working for a company as an accounting manager for 32 years and just received a letter giving me 104 weeks notice of termination, and they expect me to reduce my hours from 40 to 24 per week. So I think what you mean is, in the meantime, during these 104 weeks, you're going to be reduced from 40 to 24. So I think that's what you mean. That's going to happen now, not 2 years from now. If it's now, illegal. That's a constructive dismissal. That means you can leave now and get your full severance, which is 2 years pay, and not have to work. So you do not want to stay in a situation where you've been reduced from 40 to 24. Now, if they're saying that the reduction happens 2 years from now, they can arguably get away with that because they've given you sufficient notice. But if they're telling you, no, it's happening now, no, don't agree to it. Let's talk about constructive dismissal, Darlene. Let's get you the severance so you can leave now and still get paid. All right? Hopefully that makes sense. No, it's inappropriate. Anytime an employer reduces you that significantly, in your case from 40 to 24, that's probably a 45% reduction in hours and pay. Not legal. Constructive dismissal, 100%. So do the right thing, the smart thing. Let's connect. Okay, employmentlawyer.ca to reach me. All right. Lino, as I've said already, reach out to me so we can talk about that. Employmentlawyer.ca. Ken O'Keefe had a follow-up question. Our work relationship was okay before the medical leave, but turned to sour since then. I was asked to do the daily tracking records twice after that. I have been given negative comments by my department. So this could be a constructive dismissal. It could even be a human rights violation. I need to understand exactly what's been happening and who is involved and when it happened. So if you want to have a discussion about pursuing this by way of either a human rights complaint or a constructive dismissal claim, reach out to me. Employmentlawyer.ca, the way to do that, and I'll gladly help you. Fantastic questions today, guys. You're keeping me busy. You're keeping me on my toes. That's what I like. So please keep it up. You still have time. You still have time to ask a question right now, to get some answers, to get some help, to get some support. So don't hesitate to make sure that question gets answered. Ask it right now, and you'll get an answer. Just like Cosmic Eye. Cosmic Eye says, after 4 years, my company terminated my role. I've been offered 8 weeks of severance, including 2 weeks of notice pay. Any unused vacation days will be paid out. Should I accept or get legal advice for a better offer? Never been offered severance before, so anxious about how this works. Last year, I was put on a performance improvement plan and successfully cleared it. No performance issues this year. So the answer to this always, without exception, always is, if you've been offered a severance package, if you've been let go, you always call before signing it. Never sign this. That's true whether you've been offered $1 or $1 million. It doesn't matter, because there's a 90% chance that whatever you've been offered is not adequate. Huge chance of that. So let's break this down for you. So you've been there 4 years and you've been offered 8 weeks. Now, I don't know your age and I don't know the type of job that you were doing, but you're probably going to be owed around 6 months pay. It could even be more than that. And you've been offered 8 weeks. Now you understand why you got to connect with me, because if they get you to accept 8 weeks, you've given them a 4-month gift. Don't do that ever, ever, ever. If you lost your job, let's talk about it. 90% of the time, 90% of the people, when they are let go, are offered less, a lot less than what they're owed. Okay? So Cosmic Eye, connect with me and let's make sure you get what you're owed. All right, let's continue here. By the way, you still have some time to get in, squeeze in a question or two at the end here. So take advantage, ask it with me, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Jared has our next question. The HR person told me I'm good at my job, but said that I've been called toxic. My team has confirmed I'm not toxic. I do express my feelings about toxicity of the organization. Not sure what to do. So Jared, I'm not sure if you had asked the question earlier. Let's see here. I think you have. Okay, I see what you're saying. You're worried about a termination for cause. So if you've already been terminated, I gave you the answer. You got to call me. We'll get you severance. If you're worried about being terminated, here's what I want you to do. I want you to write to your employer. Tell them, here's what I know. Here's what people have been telling me. If you have any feedback from me, let me know what that feedback is. Make sure that they understand you're taking it seriously, that you want to understand what's happening, and you want to put that in writing. You want to put that in writing. So that's all that you can do. By doing that, you're going to make it even harder for them to terminate your employment for cause. So do that. If they try to terminate you for cause, we had that discussion. I don't imagine that the HR person is making it up. Someone must have said something about you, right? But that's not enough to be terminated for cause. So what you want to do is in writing to say, hey, I take this seriously. Give me some feedback. If there's constructive feedback, I will work on being better. By doing it that way, it's going to be that much more difficult to terminate for cause. And if they do, of course, Jared, you're going to connect with me and employmentlawyer.ca. Ken O'Keefe says, I'm in Vancouver. How can I reach you? As I've said many times, employmentlawyer.ca. All the contact information is right there. New Name says, is there a point to report a reprisal to the ministry if I'm going to immediately pursue litigation for constructive dismissal anyway? No, there's absolutely no point. We can deal with that as part of the constructive dismissal. So no, there's no point. But again, we will do a proper consultation and evaluate and assess everything, all the options and the best strategy. That's why we don't do anything without a proper consultation. And to do that, very easy. You can schedule that by reaching out through employmentlawyer.ca. Again, employmentlawyer.ca. All right. So that's the time that we have for today, guys. Thank you so much for joining me. So we had some technical difficulties. I'm sorry about that. Not sure. We'll work on that so it doesn't happen again. But right now, you have some answers. But right now, you can also continue that discussion. If you want to get my help and my team's help, very easy to do. You just go to employmentlawyer.ca. Email address, physical address, fax number, whatever you need is right there. Thank you for being with me today. Great questions, lots of questions. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'll be back here soon, but you don't have to wait. Employmentlawyer.ca. Thanks, guys. All the best.